So in our last lecture, we were talking about public means of dispute resolution, the court system. The court system, however, can be confusing. It can be unwieldy. It can be expensive. And so what we've seen, especially in the last 20, 30 years, has been the growing use of private means of dispute resolution. We know that today disputes are increasingly decided outside of the court system, meaning in another forum, the parties will decide the dispute instead of relying on the court to decide that dispute. And we call this generically alternative dispute resolution or alternate dispute resolution. And there are different forms of alternate dispute resolution. We're going to be focusing on two of them in this lecture. Alternate dispute resolution is growing increasingly important in employment litigation. We are seeing more and more claims being routed out of the court system and into alternate dispute resolution systems. We're going to see that there's a legal reason why this is occurring, and we're going to talk about the advantages and disadvantages for both employer and employee. We know that recent Supreme Court decisions indicate that in the future, within the next 10 or 20 years, most employment disputes are going to be resolved not in a court, but in a private dispute resolution system, which we'll talk about much more. So in this lecture, we're going to look at alternate forms of employment dispute resolution. As I mentioned, increasingly disputes are decided outside of the court system. Now, this alternate dispute resolution is alternative to litigation. And historically, alternate dispute resolution was not used for employment disputes. Alternate dispute resolution tended to involve companies entering into contractual disputes. So until the 1970s, employment disputes were almost always resolved in court. However, in the 1970s, we saw for the first time the use of arbitration and mediation to form parts of collective bargaining agreements, meaning a union will contract with an employer, and as part of the negotiating process, the union will agree to an alternate dispute resolution method, something like arbitration or mediation. And so in the 1970s, we started to see arbitration and mediation being included in these collective bargaining agreements. Still, however, not between employers and individual employees. In the 1990s, however, we saw a change. Now, first of all, the reason that we did not see the use of alternate dispute resolution for employer-employee disputes was that until the 1990s, a series of decisions that came out of the Supreme Court in the 1990s, the belief was employment is something different. The employment relationship, disputes arising out of that, are often based not on contractual disputes, but instead on public laws. Public laws are the basis for the employment dispute. Disputing, I was discriminated against, or I did not receive minimum wage, or I did not receive my share of overtime. These disputes were seen as public disputes and not private disputes. They were based on laws passed by the legislature. However, all that changed in the 1990s when more and more of those disputes, private disputes, were shifted into these alternate dispute resolution methods. Part of the reason was, in a weird twist, the Law of Unintended Consequences. Because in 1991, Title VII was amended. The Civil Rights Act of 1991 modified the Civil Rights Act of 1964. And the Civil Rights Act of 1991, for the first time, provided for jury trials for employment discrimination lawsuits. This was a strong incentive for employee plaintiffs and their lawyers to bring a claim, because now you got a jury to decide your dispute instead of a federal judge. And so we saw a great influx, a great increase in the number of lawsuits filed. And we also saw the damage awards skyrocket, because now we've got juries who will almost always issue higher damages than an equivalent judge would do. We've got more and more juries issuing more and more higher damage awards. And so employers, concerned about this, decided that these disputes needed not to be heard by a jury, but in a separate private resolution method. And what we also saw in the 1990s, the series of cases that came out of the Supreme Court, they said that we're going to focus on freedom of contract, and that if an employment agreement contains an agreement that disputes will be resolved according to ADR methods, then we, the court, should support that. And so in the 90s, there was a series of 3 cases, and what happened is the law changed so that now disputes involving public matters like discrimination or minimum wage or overtime could be heard in a private dispute resolution forum. And in fact, the court is taking itself out of the consideration of the merits of the dispute. That in fact, if the employer and the employee agree to a private dispute resolution method, the court is prevented from changing that. In this case, which we talked about earlier on our example of a legal citation, Mr. Jackson was an employee of a company called Rent-A-Center West. And Mr. Jackson brought a lawsuit claiming that he had been discriminated against, illegally discriminated against. Rent-A-Center immediately asked the trial court to move this case to arbitration, a private means of dispute resolution, because the employment agreement said all disputes arising out of this employment are going to be heard in arbitration. And Mr. Jackson says, I didn't know what arbitration was. I didn't know what it meant. I didn't know that I was giving up my right to a jury trial by signing this agreement. But the court said, what's important here is this a valid contract? Is there offer, acceptance, and consideration? And if that's all there, we as a court cannot go back and look at what was in your subjective mindset, what you knew or didn't know about arbitration. So these ADR methods that are supported by contracts are supported based on the notion that courts must respect the choices of the parties to the contract. Even though oftentimes, realistically, they're not choices, they're a take it or leave it choice. Nevertheless, the Supreme Court has told us over and over again that a take it or leave it choice is just the same as a negotiated choice. Now, there are different forms of alternate dispute resolution. I told you we're going to talk about 2 of them in here. Mediation is an informal procedure, and it is non-binding. We talked about in the resolution of employment discrimination suits, the EEOC will usually send the case to mediation. Mediation is really sort of an assisted negotiation. There's an independent, neutral third party that's going to help the parties try to reach an agreeable settlement. But there's nothing binding about it, that in fact, if the parties are unable to reach an agreement, then a lawsuit can occur or go on just as it always has before. Arbitration is different. Arbitration is a formal procedure, like a trial, and it binds both parties to the result. And as we'll see, arbitration is binding, so binding that there is no appeal. So an arbitration award is not appealable. It's an award that a court will never see. However, the court is required to enforce the award without judging the merits of the underlying dispute. So we'll talk more about arbitration. In fact, when we talk about these, we'll talk about advantages and disadvantages. Those will be important for your test and for your writing assignment. There are other means of ADR, alternate dispute resolution. The parties can agree to a summary trial, which is to say we'll bring in a fake jury. We bring in people that act as a jury, and we agree to a short version of our trial where maybe we skip witnesses. We just tell the jury what the witnesses would say, and then the jury will give us a result, and then we can use that number to guide our settlement or not. Oftentimes, judges will hold what's called a judicial settlement conference. The judge will bring the parties and their attorneys into a room, listen to each side's arguments, and say, look, this is what I think will happen, or this is what I think should happen. And these judicial settlement conferences give the parties a pretty clear idea of what the judge thinks should be the result of the case.